Hello, my name is Michael Tesoro, and I prepared this ACCC case note on the recent High Court case of Port of Newcastle operations and Glencore coal assets. Bit of background about myself. I'm a competition and consumer lawyer, and I work in my own legal practice, Tesoro Legal Consulting, provide people with, or companies with competition and consumer law advice. Prior to that, I worked at the ACCC in a variety of roles in enforcement, mergers and asset sales, and even did some GST, but I didn't work in the access area. The outline of the presentation, I'll discuss the background and history of the Glencore matter, then focus a bit on the decision in the High Court, and finish up by discussing the next steps, as well as some commentary about the case and the process that was undertaken. Now, the background to the case is that Port of Newcastle Operations operates the port up in Newcastle, and under the relevant legislation, the Ports and Maritime Administration Act is the ability to set prices for the services that users have to pay. And this first responded is the Glencore coal assets, which is the largest user of the port. It's the largest producer of coal in the Hunter Valley and a very large user of port services, and obviously has a very strong interest, a strong commercial interest in trying to keep the various charges down to the minimum. Now, the issues that were raised initially were in relation to the navigation service charge and the wharfage charge, but the wharfage charge was quite uncontroversial. So the case, particularly the High Court case, just focused on the navigation service charge. And it relates to two issues. Firstly, what is the scope of the navigation charge? How is it defined? What's included? What's excluded? And secondly, how do you calculate the navigation charge? Now, the way this issue is approached under the legislation is that under Part 3A, when an essential facility is setting prices, you have to try and work out what would be an appropriate amount to charge users. And the approach which both the ACCC and the courts and the tribunal use is called the building block model, which seeks to work out a maximum allowed revenue. So the major building block of this approach is a return on capital. So they're looking at how much of return on capital should the operator of essential facility be able to generate from an asset, and also it needs to work out the value of the regulated asset base. But the methodology that's applied is called the DORC methodology, which seeks to work out not the cost of replacing the asset, because that could be problematic if the asset is old, inefficient, if there's excess unused capacity. So it doesn't seek to measure the cost of replacing the assets. Rather, it constructs a hypothetical new entrant model and asks how much a hypothetical new entrant would have to pay to replace the asset using the latest technology, most up-to-date and cost-efficient technology. So basically, the price should be set at the cost of an efficient new entrant to the market, and not necessarily at the cost of the potentially inefficient incumbent. Now, the ACCC calculated the navigation service charge in the following way. It started with an optimised replacement cost of 2.17 billion, but then it reduced that amount by user contributions made by various parties to improve the port, and that meant it took $912 million off this starting point to arrive at an adjusted optimized replacement cost of 1.26 billion. And then it applied the DORC methodology to that amount and applied that to result in a DORC value of 1.16 billion. And from that amount, it was able to calculate a navigation service charge of 60 cents. Now, the approach which both the Port Tribunal took was to start with the same optimised replacement cost of 2.17 billion, but not to reduce that by the user contributions in any way. So it started with the 2.17, applied the DORC to arrive at a value of 2.08 billion, and then calculated the navigation service charge, which ended up at $1. So as you can see, there's a 40-cent difference between the ACCC's calculation and the tribunal's calculation, which is a significant amount of money. Now, the procedural history is long, somewhat convoluted. It started in 2015 with Glencore asking the NCC to recommend declaring the service, and the NCC didn't agree to that, much to the dismay of the ACCC, who was quite critical of that decision. The minister accepted the recommendation by the NCC and did not make the declaration. Glencore immediately appealed to the tribunal to review the minister's decision. And in 2016, the tribunal actually set aside the minister's decision and declared the port. Now, the port sought to challenge the tribunal's decision and launched an appeal for judicial review in the full federal court, but that was dismissed. So there we have 2017, the port has been declared. Glencore and the port sought to negotiate pricing for various services, and that continued for a while and got nowhere. So Glencore in 2017 decided to trigger the second stage of the process, which is to advise the ACCC that they had an access dispute and ask them to come in and determine that dispute. The ACCC looked at all the relevant arguments and did its calculations and issued a final determination in 2018. Now, Glencore wasn't very happy with the decision, so it appealed to the tribunal. The port was also unhappy about various aspects of the decision, so the cross appeal there. And the case went to the full federal court in 2018, and then the decision was handed down in 2019, to the tribunal, and the tribunal handed down a decision in 2019, varying the ACCC's determination. Glencore was unhappy about the tribunal decision, so it appealed to the full federal court, and the full federal court considered the matter and handed down its decision in 2020. So there's the case reference, and the full federal court found errors in the way the tribunal had decided the matter, set it aside, the decision, and remitted it back to the tribunal for determination according to law. Now, before that further decision by the tribunal could be made, Glencore appealed to the High Court. And there we have it, 2021, the High Court hands down its decision in the case. Now, the High Court decision, as I said earlier, didn't have to focus on the wharfage charge, which was uncontroversial at that time. So the focus was entirely on the navigation service charge. And there was two issues: the scope of the navigation charge, what's included, what's excluded, and also how to calculate the amount. Now, the High Court looked at the way the tribunal had determined this issue and found that their distinction between Glencore selling coal on a CIF basis and selling it on a FOB basis was artificial. Effectively, what the tribunal decided was that when Glencore sold coal on a CIF basis, it would be included in the navigation service charge, but when they sold it on FOB basis, it would be outside that charge. Now, the problem with that is that all the sales that Glencore made through an FOB basis wouldn't be subject to the regulated price that was set under the access regime. So it could be very costly for Glencore. So the tribunal's decision was described by the High Court as not focusing on the plain English meaning of words in the legislation. Term access imported this artificial distinction between the two ways of doing things. Just really go back to looking at things in a less complicated way. But the High Court also noted there that to draw this distinction would be to constrain and distort the contractual choices which Glencore was making. So obviously Glencore was making decisions to sell coal on a CIF and FOB basis for commercial reasons, which makes sense to it. But by imposing this restriction, Glencore would have to effectively, if it wanted to get the benefit of a regulated price, would have to move all its sales across to a CIF basis. So that interfering in the market in that way is inappropriate. And the High Court also commented that the approach which the tribunal had took to define Glencore as a third party for some of its sales, but not as a third party for other of its sales, was artificial, and that rather Glencore should be defined as a third party for the purposes of the access regime for all its services, and drawing this distinction between FOB and CIF prices was not appropriate. Now, the second issue was the calculation of the navigation service charge, and in this regard, the High Court decided that the full court of the Federal Court had misinterpreted the relevant provision, which is 44X1E. Now, it's a complex provision, but effectively the way it works is that under that provision, if third parties want extensions to a essential facility, they approach the operator and ask for those extensions. Now, if the operator pays for those extensions, then the amount can be included in any calculation of charges going forward. But if those additional amounts that are paid for the extension of the essential facility are paid for by the third party, by the users, and the operator of the essential facility does not grant those users an ownership interest in the essential facility, then these contributions have to be excluded from any calculation of future charges. So it's a complicated provision, but it provides for a particular scenario where you have third parties approaching an operator of an essential facility, asking for extensions, and then looking at who pays and what ownership interests are conveyed or not conveyed following the completion of the extensions. So that's what that provision is for. It isn't for a situation as occurred in the current case where extensions and improvements to the port were made and paid for by users in the past, but didn't satisfy the terms of this particular provision. So it's in effect, the High Court was saying that the full court has sought to use this provision, and so did the ACCC, to capture these user contributions when this provision wasn't able to do that. So that was an error by the full federal court. So given there was an error by the full federal court on using that particular provision, the question arose as to whether the tribunal actually had calculated the navigation service charge correctly. And as you can see, the High Court concluded that they'd done the job properly, that they'd taken into consideration the regulatory and commercial risks, that they had applied the DORC methodology properly, they hadn't sought to exclude user contributions which were not permitted to be excluded under the legislation. So their calculation of the navigation service charge was correct. Now, the disposition of the matter is that the matter has now been remitted back to the tribunal to make a decision on this issue involving FOB and CIF transactions. It's a very simple determination for them. Clearly, they've just got to decide that both sets of transactions are included in navigation service charge. They don't have to do anything on remission or the matter being remitted to them in relation to navigation charge because they got that issue correct. Just some quick comments about the case. Firstly, it's remarkable how long this process has gone. It started in 2015. Here we are in 2022. It still hasn't been resolved. The High Court's ruled, but it still has to go back to the tribunal and be finally determined. So I think this says that the process is really too long, cumbersome, and makes it very difficult for businesses to make commercial decisions in particularly in relation to essential facilities. And I think the process really needs to be streamlined some way, because you can't be waiting 7 years for a decision over a basic pricing issue. The second thing is a bit disturbing is how many conflicting decisions there were amongst the 4 major players in this space. The ACCC made a decision on the DORC amount and the navigation service charge, which the tribunal said was incorrect. The federal court then decided that the approach which the ACCC had taken was correct, but the tribunal had made a mistake on that point. And now we've got the High Court coming in and saying that the full court had made the decision that it made on the navigation service charge was wrong, and the decision made by the tribunal on the scope of the navigation charge in relation to FOB on CIF pricing was wrong as well. So there's a lot of errors being made by different players, and it just doesn't inspire much confidence in the system. It should be simpler and clearer than this, one would think. The other issue that is interesting is some of the comments which were made by both the full federal court and the High Court about the ACCC's interventionist role. The full federal court was quite critical of how interventionist the ACCC had been, particularly as it was one of the decision makers. It should really, in the court's view, be taking more of an assisting role, providing any assistance that the court may need, but being in there advocating for positions, making submissions, arguing for a particular outcome was seen, I think, by the full federal court as inappropriate. The High Court also made reference to it, as sort of a muted reference to it, but they commented, it appeared to me, favourably on the tribunal's approach to the High Court appeal, which is just to file a submitting appearance, whereas the ACCC filed submissions and was seeking to be quite active in the High Court matter. So I think this is something that there's a bit of disquiet in the courts about the ACCC in this essential facilities Part 3A area being too much of an advocate for its point of view. Really should leave it up to the courts to step into the role of the ACCC and make a final decision. And then finally, the ACCC was very critical of this decision when it came down, saying that it was going to give operators of essential facilities a windfall gain. And that's probably true, but really you can't criticise the court for the decision it reached, which appears to be correct on its face. They've made the right decision on all the relevant issues. So if there's any need for change, the ACCC really has to start looking at lobbying government for legislative amendments to ensure that these windfall gains, when they do arise, do not fall to the benefit of the operator of the essential facility. So there's work to be done there. So overall, it's a very interesting case. I thought there was a lot of back and forth and different decisions being made. And I think while the ACCC is quite unhappy about the outcome, I imagine Glencore are particularly unhappy about the outcome, given the significant difference between the two charges that were calculated. So that's all I had. If you have any questions about this presentation, please feel free to give me a call or send me an email. Bye-bye.